List of documents is a 10 documents only.
Then how, this is extraneous document, 11.1.
But it appears that the charge,
Pass on that,
charge sheet and
pass on that list of documents.
only exhibits are missing, otherwise everything is okay.
Hope so, you are not missing. Withdrawal slip was a document which has been cited in the inquiry.
That has been destroyed and that was the...
Correct, but you are not framed the charge, no? That you have destroyed, cannot misuse.
Yeah.
Why the Prasad only has misused that password?
That is his defense.
No, correct. What is the material to show that he himself, he alone is the concerned person who has used the password?
That what is the MX11? That is.
But you don't have document.
But then he says that what is it is the document cited is audit trial report, which is MX11.1.
Audit trial report means what?
Audit.
How do you identify this man has logged?
Yes, my lord. I'm just placing that it will be clear, my lord. Sri Prasad had logged in from 12. The appeal is directed against the judgment dated 6/3/2018, by which the Honorable Single Judge, after seeing the inquiry report and the consequential order of penalty.
Inquiry matter?
Yes, my lord.
List of dates?
Yes, my lord. List of dates.
Was the post held by Niranjan Prasad?
He was a PTO. That is a
PTO means?
Terminal officer.
terminal officer.
Computer terminal office.
It was a clerical post. So there is some officer, clerical.
No, there is no officer. Computer terminal operator.
Operator, sorry. It was a clerical post.
Where is the charge memo?
The charge memo is, my lord, at page. List of dates are given page. Annexure 1 and 1A, that is at page 48, my lord. Annexure 1, update petition, my lord. So, it doesn't contain any list of witness and the documents, but then I have checked up from the original record. It was charge sheet was dated and there was undated a list of documents and list of witnesses. And both the charge sheet and the list of witnesses and documents were produced at the first date of hearing.
It was produced, it was furnished to him.
It was here they have annexed only the charge sheet without any.
Then how can it be?
I don't know whether he has not denied that I have not received any list of documents.
Huh? All right, now you must have produced the record to establish that along with the charge memo, these annexure 1, 2, 3, 4 was furnished.
Lord, in the inquiry, I have at page inquiry original records indicates that it is a charge sheet with list of documents and witnesses. They have.
But it has been served on him or not?
The first page, it is not an all page, but then they have received. It is the charge memo. It is not mentioned that there is an includer.
Where is his reply?
They have not replied to that. Straight away participated in the inquiry. There is no reply. I don't know whether in my record also there is no reply. But then he participated in the inquiry, reflected inquiry, and then inquiry report was submitted. The charge will indicate that what was the nature of charge, my lord. He has in fact on a particular date scanned the signature, put a signature in the, scan the signature in the system of a person who had already died. 4 signature was scanned, treating it to be the signature of the account holder who had already died. And then 5 withdrawals were made, which were posted by him.
5 withdrawals?
5 withdrawals were made from that account.
All those 5 withdrawals slips were
Those-
subject documents?
My lord, it is further stated that they have just coming to know about that one day he will be.
Huh?
They have destroyed that also after.
Who has destroyed?
It is alleged against him.
Yeah, one of the charges that he has destroyed.
In the charge sheet, it is not there, but then in.
How can you say?
You know, my
For the purpose of proving first charge, yeah?
lord, 4, my lord, just.
Alleging that he has withdrawn 38,800 by furnishing a withdrawal slip.
Just
Whether withdrawal slip was a document which has been cited in the inquiry.
that has been destroyed, and that was the.
Correct, but you are not framed the charge, no?
Yes, my lord.
That you have destroyed.
No, yes, my lord, it is there, sorry, my lord. In the charge sheet at page 40, he then destroyed all the 5 withdrawal slips. Thus, Sri Prasad swindled and the deceased accounts money for his pecuniary benefit.
Now, what are the procedure for withdrawal slip, process of withdrawal slip? You will enter, you will make an entry in some register or something?
Yes, ledger posting. It is posted in the ledger withdrawal. On the basis of the withdrawal slip, the account is debited, and then it was destroyed.
No, in the process of withdrawal slip, is there any role of the,
Yes, he himself posted.
he himself?
Himself debited the account. This is not denied. He says that I had to because withdrawal slip has come and therefore I have debited it. But then the signature was scanned. He says that I didn't know that he is dead and therefore a signature has come for scanning. I scanned it.
No, this is cash withdrawal.
Cash withdrawal slip. It's cash withdrawal. And then the next is he was earlier posted at Boring Road branch. He was transferred, but then he went there and he logged in the system, which is not permissible as per the bank's norms. So the 2 charges were proved, and then penalty of compulsory retirement. My lord, the order will indicate that at the very outset, the petitioner submitted that since during the pendency of the writ petition, he has already superannuated on 31/1/2016, and as of today, the writ petition is relevant in view of the stigma attached. Therefore, he appears to have that I am ready for this penalty, but then since it is stigmatic, but then after then the
Where has he admitted?
yes, at the very outset, there is no admission as such, but then paragraph 2 may kindly be seen, my lord.
There are 2 of what?
The order, impugned judgment.
Impute order is at page
Next to the LPA memo of
LPA or?
LPA, it is LPA, my lord.
No, sir. That means the single judge.
Single judge.
Page? Para 2.
Para 2, my lord. At the very outset, it is submitted by the counsel for the petitioner that during pendency of the writ petition, the petitioner has crossed the age of superannuation on 31/1/2016.
You know, where is the question of superannuation when he has already retired from service as a measure of penalty on 10/12/2004? He has already retired, no? On 10/12/2004.
Compulsorily retired, compulsory.
There is a question of
I have attained the age of normal. Had he not been,
service, then only that arises.
then finally what happened, my lord, the Honorable Single Judge, after holding that the inquiry is perverse and therefore based upon no evidence, the conclusion of the inquiry report dated Ratna Annexure 2 is therefore quashed. But in view of the quashing of the finding of inquiry, the further conclusion of the disciplinary authority and plus point 5 as contained in order dated Ratna, as also the appellate order, Annexure 7, also fail as being based on no evidence. and being in violation of the principle of natural death. Since the counsel for the petitioner at the very outset has stated that the instant issue is an issue of stigma, no further direction need be passed. So they have foreclosed any action.
Who has adduced the evidence?
The bank studied evidence.
Huh? Who has adduced the evidence? Which witness?
But the inquiry report will indicate. Inquiry report is the inquiry report is not annexed, but then I have got the.
No, Annexure 2 at page 51 of the red brief.
I'm sorry. Inquiry 51 at page 51
Of writ petition.
of the writ petition.
Who has adduced the evidence in respect of respective charges?
Yes, ma'am.
Charges. First charge withdrawal and destroying.
My Lord, list of witness from the original record, it appears, my Lord. List of document, then Sri A.K. Gupta, AM Boring Road Branch, Vijay Kumar, Assistant Manager Boring Road Branch, and S.K. Misra, Head Clerk. And then I'll invite your Lordship attention to the inquiry report where it has been dealt with. 51, at page 51. Yes, my Lord. Vijay Kumar is cited witness, and then in the proceeding itself, I am Sri Vijay Kumar, working as manager DBA in serving Boring Road branch since Ratna. Then he is management witness number 1. Then management witness number 2.
Correct. What is his evidence insofar as first charge is concerned?
The inquiry report will indicate, my Lord. From exhibit placed before me and from the deposition of witness, 3 management witness and 1 defense witness, page 51. The following points came to light. 3 withdrawal was posted by Sri Niranjan Prasad, holding code number C. There was a code attached to him, C444, and they were passed on the basis of signature scanned by Sri Prasad on 2011-2022. 52 below. The defense in his argument said that scanning was done by some other number using his code and password. But the witness of both the sides have deposed that it is not possible to know other password. The defense witness, who is close friend of CSE, charge sheet employee, answer to question number C2DW1 in page 4, also deposed that nobody can know other password. Refer reply to cross-examination question 2D1 and C8.
No, what is the basis that he has committed this? password can be used by such of those passwords are allotted to staff. It is not that Prasad alone has been given.
No, he has, every person has a unique password.
Correct.
So he-
Why the other person cannot misuse?
Yeah.
Why the Prasad only has misused that password?
that is his defense.
No, correct. What is the material to show that he himself, he alone is the concerned person who has used the password? If you have given password to more than one person, why can't the other person is not liable?
No, this password is, everybody has a password of his own.
Ah, yes, correct.
He cannot use the other password because that password is entered. Whenever a transaction takes place using the password, then it is indicated who has opened this and what time and by who.
Correct. Prasad has utilized that.
This-
Assuming that 1, 2, 3.
He admitted that this password was utilized, but whether he utilized or others,
From his password only this transaction has taken place.
Ah, yes.
For that purpose, what is the document?
no, that is the, they don't deny. He says that.
No, what is the document, sir?
Just placing the documents.
Password or not? Okay. Place that.
List of documents में user and login status report. List of documents.
Huh?
Among the list of documents, one is the user and login status report. So we indicate date-wise who has logged in and who has logged out,
Huh.
and for what purposes.
No, where is that material? For what purpose he has entered?
He has scanned the signature of deceased account holder. Using this, it is admitted that signature was scanned by C0004. He says that I have not. But then it is assigned to him alone.
I'm not able to understand how the password has been used.
No.
Time.
130.
The password. Password? Secure.
Inquiry authority का report. If any person makes a withdrawal from any account, my lord, then he has to put in password to open that account, and then he can enter the amount, then withdrawal, debit, credit, whatever. So that is reflected always. So the history status report indicated that on that particular date, when the signature was scanned of the deceased account holder,
Who is the custodian of withdrawal slip?
withdrawal slip is open.
Huh? No, after processing, after withdrawing, who is the custodian? No, the next question is
Yes.
that he has destroyed. Whether he is a custodian of those withdrawal slip? He is a computer, what is that?
Computer terminal operator.
Whether he is a custodian of withdrawal slip after withdrawing?
He is not only operator only. He is working as an employee for at the counter for debiting. He says that
All right, sir, who is the custodian of withdrawal slip
after
after transaction?
voucher posting supplement.
Manager and next officer.
It is not there that once it has gone to a the person who is custodian, then it was destroyed. It might have been destroyed at the very initial stage after debiting the account. Therefore, there is no date when it was destroyed. Because
All right, sir, withdrawal slips transaction is over. Now that is required to be
Kept.
under custodian or taking register number, entering and other things.
that
He
is,
can't solely decide all those issues. There must be a supervisor officer.
eight doc,
From your bank manual, you have to deal with all these things. Who was the custodian and other things?
column 8 is the document number 8 is voucher posting history. Supplementary cash book of HSS account of dated जो 5 transactions हुए उसका, that is there, the 5 transaction. So therefore everything was there, my lord, in the inquiry proceeding, and then the inquiry officer came to the finding, and the inquiry officer being a person who is in know of the everything, and then
Inquiry officer?
inquiry officer is also a bank officer. So he knows how the transaction takes place, and then
That's the
he,
reason we have to apprise.
Yes, ma'am.
Where he has stated that withdrawal slip is the custodian of so and so.
my lord, the
At what point of time the withdrawal slip are missing or destroyed?
other two withdrawals are posted by other two. MW2 in reply to question number 9, page 80, deposed that withdrawal may have been destroyed by interested party.
This is only presumption.
The person who has scanned the signature must be party interested in the case, because he has scanned a signature of that person. As Sri Prasad have scanned the signature, he must have destroyed the withdrawal slips. Defense also tried to mislead, showing that Sita Nehu mentioned in the user code column, and the password neither MW1 to 3 nor DW have told that those are passwords. Although the MW2 have deposed that there was charcha of a display of secret information on the screen of computer. Refer page 91-92. Neither he personally faced any such display. Defense witness again said that the password used to be displayed in case of pushing wrong button. Answer to question number 4 of the examination in chief of page 101. But he did not say that the password of the other staff have ever been displayed. The MW2 was not knowing the written information given to Banks Authority about the displaying of the secret information or not. DW1 also deposed that the lacuna of the
Whether preliminary investigation or inquiry was held?
it appears so. And they put letter to receive investigation report on fraud, my lord. It is there in the original reports. It is not
Investigation report. Who has conducted investigation?
727.
Has he been cited as witness?
727. Seven to 27. Senior Internal Auditor D.P. Sinha. Conclusion: in the light of the foregoing discussion, I am of the firm opinion that all 5 fraudulent withdrawals were prepared by Mr. Niranjan Prasad and Mr. Niranjan Prasad alone. Mr. Manoj Kumar, manager operation, was on transit leave till 2011-2002, the first day of fraudulent withdrawal. Also at his initiative, fraud was detected, hence he has been kept out of the range of suspicion. Branch authority have to be requested to segregate and keep the relevant records under safe custody. User ID of all these members of the staff who have been transferred out were on long leave was got suspended during the course of investigation. The scanner were got placed in the server room. The instance of multiple user ID were got rectified and confirmation of a specimen signature module was got shifted from special assistant officer level to DBA level. Branch may kindly be advised to take other desired precaution in the light of the aforesaid discussion to avoid recurrence of such incidents in future. They may also scan similar accounts to detect frauds, if any, committed in those accounts by adopting the similar modus operandi. And then it is 29. He is not cited as witness, my lord, nor the investigation report is one of the documents cited.
No, who has given evidence in respect of withdrawal of 5 slips?
Yes.
One and 52. Zoning officer. Which evidence has been taken?
Do you have a copy of management witness number 2 who has deposed?
That is the missing part from the because there was criminal trial going on. The document was sent to the prosecution agency, my lord.
Most of the bank cases records are missing.
But only exhibits are missing, others are there, my lord. They have given me letter that the
Officials are missing.
exhibits are missing, my lord.
No, officials are also missing.
Maybe, my lord, that time who was the official?
No, in whichever bank matter you are appearing,
Sorry.
records are not made available.
Because I have brought the record, my lord, also.
Because take page 51 and 51 and 52 and 53. Sorry, 50, 51, 52, 53.
Only
In
refer,
respect of charge number 1 is concerned, except MW2, no one has given evidence. What is the evidence given by M2? On the other hand, once at one given point of time, he says that destroying the records is concerned, may interested party have destroyed.
While deposition, my lord, MW1, please look into the and tell the inquiry what is this. This is user and login status report of Boring Road branch. Please accept and mark as management exhibits. Accepted.
MW2 says that although the MW2 have deposed that there was a charcha of display of secret information on the screen of the computer refer page for 9192. Neither he personally faced any such display. On presumption, he is giving evidence.
The circumstance is that once the document is destroyed, only catch point was that his user ID was used for scanning, and he has himself posted. He admits that I have posted it, but then says that I am duty bound to post any withdrawal which comes to my desk. In the reply to the inquiry report, just placing that is at page
What is this MEX 11.1?
management exhibit.
exhibit.
Exhibit 11.1.
Submission to the inquiry report is at page 63, my lord.
First charge is not put. Second, what is the second charge?
Second charge is that he, after transfer, visited the branch from where he was transferred and he used the password which was not withdrawn and logged in the account.
Now, how can he log? When he has been transferred, automatically the password will be changed.
It was not changed by mistake and then he
So,
advantage of that, he logged
what action you have taken against manager in not changing the password?
The charge number 1 is also
What he has done on 29.
my submission is the charge number 1 is also proved from the. I'm just placing his submission.
No, there is no evidence, sir.
Has been-
In fact of charge number 1, very vague statement has been made by management witness number 2.
My lord, he admits in the submission to the inquiry, it has been alleged that I scanned
So,
such admission like that.
don't say what is not there.
Now I am dealing the factual position on the basis of documentary evidences and deposition witness, which came into light during inquiry proceeding. It has been alleged that I scanned a false signature of late Sri S.N. Sinha of HSS account, but nowhere during the inquiry proceeding it has come to the light that the signature scanned by my code was a fake one. He had that, therefore there could not be any signature. It has the signature of HS account was scanned by my code is deposed by MW1 in question number 76 on page 36 as per Management Exhibit 7. If it is so, then it is a normal routine duty. While deposing of day-to-day routine work, which is the instance case on perusal of MEX 7, which is a report given by Jitendra Kumar, computer engineer of Nelliad system, it is found that so-called fake signature was confirmed on Itna by a code BM Itna deposed by MW1 in OD number 1 on page number 47, which belongs to Manoj Kumar, manager operation. But on perusal of defense exhibit, which is again a report of expert of computer Sri Jitendra Kumar, computer. I'm sorry.
What was the misconduct committed on 28/12/2002 and 29/1/2003 after his transfer?
It is find the so-called fake signature
No, after logging that.
logging.
What he has committed?
That with respect to charge number 2, it is submitted that none of the witness of management had said that they have seen operating the computer on alleged dates 28 Itna after my transfer from Boring Road branch. Whereas the defense witness DW1 has said that I had come with him on those dates for taking salary, so he visited that branch. And educational defense witness loan for my son and remained together with him. I did not touch my computer terminal at Boring Road branch since departure with him. As question 2.
No, you have mentioned in the charge number 2, date and time and second minutes. Where do you get this? By which document?
That is the computer printout.
That is cited as a document.
Twenty-eight 12. Yes, my lord.
What is the document?
Audit trial report, login history of 28/12/2002 and 29/1/2000.
Cited as exhibit as what? Management exhibit 11 within bracket 1. What is that? No, from the list of document you see, sir, Exhibit, management exhibit 11 within bracket 1.
List of documents is a 10 documents only.
Then how, this is extraneous document, 11.1.
But then it appears that the charge,
Pass on that,
charge sheet and
pass on that list of documents.
so, only exhibits are missing, otherwise everything is okay.
Hope so, you are not missing.
I am here to assist your lordship always.
This is the list of documents.
The list of documents is at page, probably at
List of original documents of departmental proceedings.
30, at page 30, my lord. Internal page 30.
Huh?
Internal page 30 of that
30?
30. 29 is the charge sheet begins, and thereafter 2 pages charge sheet, and then 30, 31 documents, 31, page 31 it appears. At
No,
page-
you have taken extraneous material. Exhibit 11.1,
No, exhibit
take page 55.
1 and 2 is the charge.
Take page 55. Page 55?
Yes.
Line number 5, fifth line.
11.1.
11.1. Where is that?
My lord,
It's not extraneous
no,
material.
my lord, what happened? I have gone through the inquiry report.
Not
Inquiry,
inquiry report.
inquiry proceeding. They have marked the charge sheet as MX1. Then they have marked list of documents as
Then show us from the list of documents, this is the document.
This is the documenting. This cited, then chart number 2 is login form.
my lord, sorry. Audit trial report.
Log. The time.
My lord,
Correct. Audit trial report. Audit. Audit. Audit trial report author is going to be examined. No? Audit trial report. No. It is assigned. Here exhibit 11.1. By the referring to
What do you say about charge number 2?
Submission is my lords.
Lord, the exhibit, number of exhibit has been increased because of that. He has filed as counter affidavit in which he says that the charge sheet and the PPO letter is MX1 and the 11.1 is given audit trial report.
Huh?
The counter affidavit he has filed. My lord. He has admitted that what is the MX11. That is,
But you don't have document.
but then he says that what is, it is the document cited is audit trial report, which is MX 11.1.
Audit trial report means what?
Audit trial report, login and logout report of code office.
What is meant by audit trial report?
And in that it was stated that he had logged in and therefore.
Lord's submission is that firstly, as your lordships have seen, they did not furnish any list of witness or list of documents. Secondly, my lords, in the
Have you raised such contention before the single?
lords, before of course, the writ petition, it is mentioned. And my lords,
Mentioned what?
I
This one.
have filed a reply to the chargeman. Only
Oh,
this much.
but you don't have copy.
No, the document is not. In fact, my lords.
And but they are disputing that you have not filed your.
No, that is, they have not denied it. In the writ petition, I have clearly made a statement, my lords, that
I don't find
pursuant
the
to
writ
this
petition therefore.
writ petition,
नहीं find कर रहे थे उसको.
writ petition, they-
It is stated letter number probably. Yeah.
In the writ petition, where have you stated?
in para 5 at page 12, annexure 1 and 1A are the charge. It is relevant to state here that the petitioner in pursuant to the charge sheet as contained annexure 1 and 1A filed his reply and cooperated with. So he had filed his reply
Where are you reading?
at page 12, para 5.
Page 12 of writ petition.
My lords.
Oh, para 2, 3 is there.
In para 5 of the writ petition at page 12, he is saying that it is relevant to state here that the petitioner in pursuance of the charge sheet as contained in annexure 1 and 1A filed his reply and also cooperated in the departmental proceeding. It is significant to state that in the departmental proceeding, MW1 Vijay Kumar, assistant manager, MW2 Sushil Kumar Mishra, head cashier at present assistant manager, were examined on behalf of the management. DW1 Dilip Kumar, CTO, was examined on behalf of the petitioner.
And then out
But it
of
has,
the
but it has, and then charge.
Three management
then-
witnesses who were examined, my lords,
List.
as your lordships have seen in the inquiry report, there is reference to only to MW2. There-
Kumar.
Lordships, there is absolutely no discussion or reference to any of the other MWs, my lords.
No, that is insofar as first charge is concerned.
Lordships.
What about second charge? Second charge is with reference to audit trial report.
My lords, audit trial report, my lords, the objection, neither the author of that document nor
Who is the author of that document?
that is, my
That is
lords.
only a computer printout.
No, kindly, audit report.
Login report.
No, it is not an audit report. It is an audit trial report. What is the trial report?
Even that author has not been examined, and all these.
Sir, where is that report? According to you, audit trial report. No, but they have referred to some computer printout. That's all.
My lords, who had taken many.
Which cannot be signed. You must be aware.
True, my lords.
Electronic documents which cannot be signed.
True, my lords, but there is absolutely no reference to these things in the inquiry report, and a copy of the inquiry report which had been furnished to me, my lords, I immediately filed a detailed reply as I had been asked, and that reply your lordships will find at page 8.
But we find something insofar as proving second charge.
No, my lords, the submission,
No, why did you log?
my lords,
Why did you log?
no, I had never logged, that is what I submit.
Who log? In your name.
My lords, I had clearly mentioned, my lords, that I had visited for the purpose of taking my salary as my salary was being credited there. And secondly, the education loan for my son had been taken. The disbursement of the education loan was due. Only for those twin purposes I had gone.
No, that is not personal this thing. No, it is an official password. How can you use official password?
Once, my lords, I get transferred, any officer or a staff gets transferred.
No, whether official transaction and personal transaction are mixed and only one password is given.
Yes, and there can,
Was document. I don't think.
the personal transaction can never be made through.
Sir, if your salary is transferred in your account, how can you use official password?
No, I have not used the password for that purpose. I have never, for that purpose, once my salary is there, I have to go and simply sign a check or withdrawal and then take my salary for, if I am getting cash payment.
Then why did you use the password?
System.
Why did you use the password?
Once I get transferred, I can never use the system. That is only for the staff.
But the timing, seconds, minutes, everything is displayed in exhibit L1, 11.1.
11.1, my lords. On that, my lords, kindly see what is the finding. Now, so far as charge number 2 is concerned, from page 54 in the inquiry report, my lords, the second charge is Niranjan Prasad have unauthorizedly operated the computer by logging into the computer system on 28 December and 29 January. That is after his transfer to zonal office, Patna on 7 December 2002. From the deposition of the defense witness number 1, who is a close friend of CSC, it is clear that Niranjan Prasad CSC had visited Boring Road branch on 28 December 2002 and 29 January 2002. Refer reply to DW1 against DR question number so and so. In reply to question number 9 of DR, the DW1 said that he came to withdraw the salary and the CSC came for the disbursement of a loan. Although along with DW1 deposed that CSC was with him all along while visiting the branch on 28 December and 29 January 2003. Therefore, my lords, the submission is, my lords, it was all false charge and it was never proved by means of any document. Now, referring to MEX 11.
Your password is in connection with this transaction is there or not? Transaction.
No transaction. This login, whatever is said, my lords, there is no allegation of transaction because you.
With reference to that so and so have listed from 11.1 report.
I went with that person, but I was always with him and he didn't help.
The list of logging. He has operated on particular times. Possibly. One thing, 11.1, there are 20 of logged. This logged for that purpose. Who's on that? He has logged on 12:41.
And so far as the withdrawals, alleged withdrawals are.
No, how did they identify that you have logged in at 12:50 and 12:52?
My lord,
12:52 for 2 minutes, for about 2 minutes on one day, another day for about 7 minutes. How do you identify?
Lord, the defense representative replied, inquiry authority itself says that how it has come. Lord, at page 55, in reply to question number 9 of defense representative.
What is the question number? What is the question?
Question number 9. उसमें होगा page 103.
How many questions were prepared? 70, 80?
The number is not very relevant because what is the substance he has said that he came to withdraw the salary. So another person went there to withdraw salary and CSE came for disbursement of loan for his son as vice president along with DW1 depot that CSE was with him. So he,
Sir, how do you identify this man has logged?
yes, my lord, I'm just placing that it will be clear, my lord. Mr. Prasad had logged in from 12:50:41.
Correct. What is the basis to come to the conclusion? Take 11, exhibit 11.
Exhibits are missing, my lord, but then it is.
No, just now we have seen. Exhibit 11:1. From that chart, how do you identify that respondent has transacted?
8-1. C0004 login. C0004 login. Successfully logged in and logged out.
No, we are asking you, sir, we are asking you, there are 10 or 30 login. That the petitioner, respondent, he himself has logged in.
Yes,
To that effect, what is the material?
that is the password. Login
Password is entered, how can you disclose?
0004. All passwords are there. Whoever has logged in. Passwords are there at page 26. And then it has been stated by the inquiry report also, in the inquiry report also that
If password is entered in exhibit 11, you don't have case on charge number 2.
Kindly see what is the, now the only material that is one MEX7,
Yes,
Management Exhibit 7.
11:1.
No, and another, that is Exhibit 7 is a Nelito Systems report.
Huh?
The report on the basis of which,
Where is that reference exhibit 7?
kindly see the single judge's orders, 2 paragraphs.
Yeah, we have to deal with the inquiring officer's report in the.
The inquiry officer has not said about MEX7, but the disciplinary authority, he is taking those points because I was never given a chance to meet any of the inquiry officer's report was said.
What is that exhibit 7?
Exhibit 7 is, that is a report submitted by expert of the computers, Messrs. Nelito Systems Limited, Jitendra Kumar, who was not examined. He is the author.
But the disciplinary authority has taken note of that.
And yes, and what he says that is a defective system. The audit report that the system developed by Nelito Systems is defective and passwords do not remain confidential. And it is possible that any other person who is vested interest can misuse the user code and password of any other staff for ulterior reasons. That is the finding. He is not able to meet that in paragraphs 5 and 6 of the
Now, from the disciplinary authority order, you point out where is that reference to exhibit 7?
losses. My lords, kindly at disciplinary authority, second so-called first, my lords, and except 4 at page,
No, disciplinary authority's order.
because in the second
Imposing punishment.
so-called also that was mentioned.
it is his defense, my lord.
No, second so-called also.
No, in the inquiry, in the disciplinary authority order, it is his defense that the point of defense that the password which was a secret
Kindly see
code.
disciplinary authority order, my lords.
Ah,
That is an except 5, page 75 it is.
page 78.
My lords, 77 first, my lords,
No, sir.
Last but one, page 77, annexures, MEX 7,
Sir, page 78,
Lot.
page number 2,
lordships.
just down below that. There is no reference to exhibit 7.
Report is there.
At page 77,
79 also, there is no reference to
kindly come to 77, my lord.
77.
Lordships. The last but one paragraph, as per MEX 7, signature history listing, signature in HSS account number C3 was scanned and so by user codes on the user ED, so the code of Niranjan Prasad CSC deposed by MW1 in question number so and so. And it has come in evidence that that is a defective system. Anybody can use anybody's password or system.
What is this D2 case? On page 77 only, hence my findings in this D2 case is put here.
No, not DE, departmental inquiry. That is a misprint perhaps.
D case is put.
Lordships. So they are, both the inquiry officer or the disciplinary authority in second SOPA as in the disciplinary order, they are referring to materials.
This bank council, where is the exhibit MEA X7?
7 history, signature, history,
Inquiring officer has not dealt with that matter.
signature history listing.
But he is the,
Correct, but the inquiring officer has not dealt with exhibit M7. In the absence of that, how disciplinary authority is relying on, assuming that if he is disagreeing with the inquiring officer's report, the petitioner is entitled to notice insofar as examination of MA exhibit 7.
nothing was done, all these things.
No, my lord, charge number 1, my lord.
Don't go to the charge number 1, we are in charge number 2.
It is in relation to charge number 1, my lord.
Exhibit M7.
MEX7, which has been cited by the disciplinary authority. And then I'll see.
No, in the inquiring officer's report, you point out where is the reference to M exhibit 7? Page 55. No, 51 to 50.
51 too.
Ah.
My lord, the inquiry officer says that from the exhibits placed before me and from the deposition of witnesses, 3 management witness and 1 deputy.
Very vague.
So they said that all exhibits were placed before him.
Correct. It is a perverse evidence.
Perverse evidence, perverse finding and perverse and imposition of penalty.
And my lord, then the concluding portion is that since he has already superannuated and
How is it relevant?
that since the counsel for the petitioner at the very outset has stated that instant issue is an issue of stigma, no further direction need be issued. Therefore, no remand is there, my lord.
Huh?
There is no remand for fresh inquiry from the stage of inquiry or disciplinary authority. There is nothing.
Yes. So what is required to be done?
If the case of the respondent is that some extraneous material has been relied upon by the disciplinary authority, then from that stage it can be done.
Why he has already retired from service? And you have already taken a decision to impose the penalty of compulsory retirement. And you can't, from even assuming that if the matter is remanded, you can't impose the penalty of compulsory retirement. Because he sees to be, there is no relationship of master and servant.
It is the relationship of master and servant will date back to the date of inquiry.
How can it?
Because there is a clause which says that if before superannuation charge sheet is issued,
Because,
that is there in the regulation.
because from the regulation. Which kind? You have a regulation.
No, that is
I don't know, you people, why without a regulation appear?
Regulation are there, my lord, but I was thinking about that he's an officer.
Sir, you are a panel counsel.
Yes, sir.
Why can't you retain one regulation copy?
The regulation copy is here, my lord.
Pass on that regulation.
That regulation is in relation to the officer. So far the staff is concerned, there is a bipartite,
Bipartite settlement.
which I have also got.
Bipartite is not there after
Ah.
the normal age of superannuation. Normal age of superannuation is January 2016.
I always take care to come before your lordship with the regulations.
We could not make out a person who has retired.
There is no.
Departmental inquiry will continue.
By part it is silent.
No, no, it is not there.
So you can't.
Whatever materials I had before me, my lord, I have placed. But if such a person is allowed to go scot-free, my lord,
Correct, but you have not taken proper action, no?
because he is not in the bank now.
Court will interfere only in respect of departmental inquiry if there is a perverse evidence or on legal issues.
Therefore, in fact, the Honorable Single Judge has reappraised everything.
All right, we will set aside all those observations. We will take only that he has not been provided list of documents, statement of imputation.
They have not alleged it anywhere, my lord.
That is a legal issue.
No, but they have not alleged. I don't know whether it has been served or not, but then it appears from the charge sheet.
You should,
Annexed.
you can't take only signature. You have to say that, you have to take his signature that these many documents have been received by him.
The charge memo does not contain at the end any list of witness or list of documents.
No, my lord, the original record is there is a forwarding letter containing the charge sheet and the list of witnesses.
Sir, the charge memo consisting of page 1 and 2, that's all.
That is the charge sheet annexed by him, my lord. But then from the
No, it must accompany list of documents and statement of
it is-
participation, documents and witness.
either
Therefore, you have prepared independently.
but then it is
All right, you pass on that list of documents and list of witnesses.
just 28, page 28 or 28 to page 31 may kindly be seen. If it doesn't convince your lordship, then the matter ends. my lord. Page 28 onward. नीचे वाला देखो नीचे कोई पेपर है निकाल दीजिए 28 it is a forwarding letter it appears my lord containing the charge sheet 28 page 28.
Where is the list of documents?
At page 38 probably.
It is unsigned. Though it is original, there is no date.
Then in the page 20
No date, yeah.
indicates that you produce
There is
this.
no date, one thing, the pagination should have been continued. Page number 3,
Might have been
It should have been.
inserted later.
and this is only list of documents, witnesses. Statement of imputation is not there.
Page 28 may kindly see the direction upon the presenting officer either probably
Huh?
produce those documents and page 28 may kindly be seen.
28. What is this?
It is a 194 probably letter.
Saha is hereby directed to produce documents. File. No, this is appointment of what?
Present.
Inquiring officer. For inquiring officer, he has given instruction.
This is all. ये ना लिख रहा है उसके साथ उसका अक्षर नहीं कर I quite appreciate that it is not annexure 1 and 2. Perhaps it should have been like that.
And also, assuming that it is an independent document, pagination, you say that page number 1 and 2, charge memo. Next should be 3, 4.
But then it has been placed before the inquiry officer by the presenting marked as Exhibit 1 charge sheet and then the list of documents and witness MEX 2.
And that apart, there is no date.
Date is probably 30th November.
And there is no file number on the list of documents. And you don't have original charge sheet? This is the Xerox. List of documents is original. What type of record is being maintained? Xerox, Xerox. Huh? Yes, take down. Present LPA is presented. by the management bank questioning the validity of the order of the learned single judge dated 6/3/2018. Respondent, while working as a computer terminal operator, he was subjected to disciplinary proceedings in framing two charges. Charges are as under. Now, 48 of repetition 1 and 2. A respondent is stated to have filed a reply, however, it is disputed by the appellant. Full stop. Inquiry was held against the aforementioned charges, and the inquiring officer has given his finding in the report that both the charges were proved. Full stop. Based on the inquiring records, the authority proceeded to impose the penalty of compulsory retirement on 10/12/2004. Full stop. Feeling aggrieved by the order of penalty, respondent preferred appeal, in which he has preferred order on 2/8/2005. The result, a respondent filed CWJC 11756 of 2005, and it was allowed by the learned single on 6/3/2018. Hence, the present LPA by the bank. And counsel for the appellant bank submitted that charges leveled against the respondent were proved in the manner known to the law. Therefore, the learned single judge has committed error in contending that perverse evidence further, the disciplinary authority has taken note of MEX-7, which is stated to be a report of Mr. Jitendra Kumar, within bracket computer engineer. It is not part and parcel of departmental inquiry. The inquiring officer has not referred to MEX-7. to stop. On this point, land counsel for the appellant submitted that the inquiring officer, whichever the documents made available to him has been taken note of. Therefore, there is no error committed by disciplinary authority insofar as relying on exhibit MEX-7. It is further submitted that respondent has had fraudulently withdrawn money of a bank customer within bracket dead persons while forging his signature through scanning, and it is a serious charge. Full stop. The other charge is relating to login with the password by the respondent after his transfer on 2 days. Once he has been transferred from a particular branch, he is not supposed to utilize the password and log in the system. On this charge, exhibit 11.1 suffice to prove that he had logged in. For control and counsel for the respondent resisted the aforementioned contentions and supported the order on single judge. He vehemently contended that along with the charge memo, the appellant was required to furnish a list of documents, a list of witnesses. No, before that, statement of imputation, comma, list of documents and list of witnesses. However, it was not made available to the respondent. Further, the disciplinary authority has relied on extraneous document, namely MEX-7, which was not part and parcel of inquiring officer's report. In other words, MEX-7 has not been analyzed, either proving the relevant charge read with the examination and the cross-examination of the author of that document, namely Sri Jitendra Kumar, computer engineer. Further, if the disciplinary authority is taking note of exhibit MEX-7 and it has not been taken note of by the inquiring authority, in such an event, one has to draw inference that disciplinary authority is disagreeing with the inquiring officer's report with reference to material. If it is so, the disciplinary authority should have resorted to issuance of a show cause notice to the extent that he is disagreeing with the inquiring officer's report and he intends to rely on MEX-7 and to examine and cross-examine Sri Jitendra Kumar, or the matter should have been remanded to,
Were examined, Jitendra Kumar was.
matter should have been referred back to the inquiring authority to commence the inquiry from the defective stage. Such steps have not been taken by the disciplinary authority. Thereby, a respondent has been denied opportunity of his say on exhibit M7, exhibit MEX 7. Therefore, there is no infirmity in the order of the land single judge. Heard the land counsels for the respective parties. Undisputed facts are that respondent Niranjan Prasad was subjected to disciplinary proceedings while framing 2 articles of charges. The inquiry was concluded in proving the alleged charge. Based on the inquiring officer's report, disciplinary authority proceeded to impose the penalty of compulsory retirement, and it was affirmed by the appellate authority. The learned single judge set aside the penalty of compulsory retirement while allowing CWJC number 11756 of 2005. The appellant presented the LPA while questioning the order of the learned single judge dated 6/3/2018 passed in CWJC 11756 of 2005. First, the learned counsel for the appellant in support of LPA submitted that learned single judge has committed error in not appreciating that the charges were proved in the manner known to the law. Therefore, he has committed error in interfering with the penalty order. It is also submitted that a respondent has fraudulently withdrawn the money of a debt customer who has died as on the date of alleged fraudulent transaction, and further logging without authority of law when he was transferred from the concerned branch. So these are the 2 charges which are serious in nature. The 2 in respect of a financial institution like the appellant bank who are transacting with its customers and who have trusted with the appellant bank. Therefore, there is no infirmity in imposition of penalty of compulsory retirement. Next, the learned counsel for the appellant's contention is entirely on merits. Ordinarily, courts would not interfere on merits in a disciplinary proceedings. In the present case, insofar as charge number 1 is concerned, perusal of the finding of the inquiring officer, it is crystal clear that it is a case of no evidence. So far as charge number 2 is concerned, even though evidence is available to the extent that exhibit 11.1, MEX 11.1 which suffice to prove that respondent had illegally logged in on those particular two dates which are cited in the charge memo. Therefore, charge number 2 is rightly proved. Full stop. Next paragraph. Charge number, even though charge number 2 is held to be proved, however, on legal issue, the appellants have not made out a case for the reasons that petitioner has not been made available exhibits, not made available while furnishing charge memo. To stop. He has not been provided statement of imputation, commas, list of documents and list of witnesses. To stop. In this regard, appellant bank have not produced any material to show that they have provided documents. To stop. In this regard, it is necessary to take note of Apex Court decision in the case of so and so Mandal, reported in 2000. In view of the above decision, in the principle laid down, the aforementioned decision of the Apex Court is that in a departmental inquiry, list of statement of imputation, list of documents and list of witnesses were to be provided to person. The principle laid down by the Apex Court in the cited decision is aptly applicable to the case in hand. Next paragraph. The disciplinary authority has exceeded his jurisdiction in relying on extraneous material like exhibit MEX 7, which is not part and parcel of inquiring officer's report. If disciplinary authority is relying on extraneous material, in that event, respondent was entitled to have the benefit of notice and other formalities, including examination and cross-examination of the author of exhibit MEX 7, namely Sri Jitendra Kumar, within bracket computer engineer. In the light of these facts and circumstances, the appellant bank have not made out a case so as to interfere with the learned single judge order. Accordingly, appeal LPS stand dismissed. The petition order of the learned single judge is affirmed.
You will be entitled to the benefits, sir.
Huh?
You will be entitled to the benefits.
As a respondent, can you ask? In the writ petition, a single judge has given or not?
No, he has not given, that is why. He has not given.
Removed.
From the date of compulsory retirement till the normal date of superannuation.
But you are not discharged the duties.
So at least the pensionary benefits can be computed from that day if your lordship will kindly observe. Of course, my lordship, not on this. So if your lordship will be kind enough to observe, at least for retirement benefits.
Appellants are hereby directed to count the service from the date of compulsory retirement till normal retirement.
There being no cross appeal.
If he was in service, that date may be taken into consideration for the purpose of extending retirement benefits only. same shall be considered and monetary benefit shall be calculated and disbursed within a period of 3 months from the date of receipt of this order.